head of Holland & Hart's Health Law Group, and today we are going to be taking on our next in our series of compliance webinars. This compliance webinar series, because of the COVID pandemic, we've changed our format. Instead of doing live presentations in person, we're trying to do a weekly compliance web bootcamp webinar for all of those who might need the information. I'm coming to you live from my home here, my messy office, so I apologize if there's interruptions in the back. Hopefully I don't end up on YouTube with one of those types of situations. As I mentioned, this is the next in our compliance webinar series. We've already talked about the Provider Relief Fund, New Stark and Anti-Kickback rules, telehealth and vaccinations. Today we're going to be focusing on specific Idaho issues that Idaho healthcare providers need to be concerned about. We'll continue talking about some of those federal issues in later webinars. Particularly this Thursday, I'll be picking up and talking about the federal fraud and abuse laws. We'll talk about Nevada compliance issues on the 26th. On the 28th, we'll be talking about information blocking rule. And then there's a whole list of future webinars that we've got coming up. If you haven't been getting those, the information concerning those webinars and you would like it, just by all means let us know and we'll make sure that we get you that information. So here's the things we're going to talk about today. I'm going to talk about the Idaho-specific fraud and abuse laws, the Idaho Patient Act, which is causing a lot of people grief. We're going to talk about consent issues because that's a common compliance issue, a common issue that comes up a lot that providers have questions about. We'll talk about Idaho's telehealth laws, and then a couple of new pieces of legislation. We're going to be moving pretty fast, so we're really only going to have time to kind of give a highlight to alert you to some of these issues and to give you kind of pointers on some of the issues. But if you have questions, by all means, use the chat feature to submit those to me or send me an email and I'll respond to those offline. Because we're recording the webinar today, we're not going to take questions during the program, but I'd be happy to respond offline. We have provided you with a whole bunch of written materials, primarily different articles that we've written addressing these particular issues. Those are available at our website, or you can, if you didn't get those, you can contact Laura Squires at LDSQUYRES at hollandandhart.com, and we'll make sure that Laura gets those slides to you. With that said, let's talk about Idaho fraud and abuse laws. You're familiar with the federal fraud and abuse laws, the things like the False Claims Act, the Anti-Kickback Statute, Stark, and the like. These are the things I'm going to be talking about on Thursday on a federal level. But you also have to be concerned about Idaho laws. Sometimes the Idaho laws get forgotten. So we're going to talk about some of those Idaho laws today. The first is the Idaho False Claims Act, which is very similar to the federal statute. Under the Idaho statute, you cannot knowingly submit a claim that is incorrect for payment by Medicaid. In addition, you can't make false statements in any document that you submit to the state. You can't submit a claim for medically unnecessary items or services. Fail repeatedly or substantially to comply with Department of Health and Welfare rules. Now, that's a bit of a sticky wicket because they essentially turn the department rules into situations where you could be held liable for False Claims Act penalties. So you have to be careful that you know and are able to comply with those Department of Health and Welfare rules. Also, you can also get hit up with penalties if you breach the provider agreement. So each of you presumably have signed a Medicaid provider agreement for those of you who are participating in Medicaid. If you have and you breach some of those terms, then you can be liable just as if you violated statute or another regulation. We'll talk about what some of those terms are in just a minute. Like the federal statute, under the Idaho statute, if you have submitted a claim improperly or you've been overpaid, then you have an affirmative obligation to report and repay that amount that you have improperly received. Now, under the federal statute, you've got a timeline, generally 60 days. Under the state statute, there isn't such a timeline, but when I've worked with the Medicaid unit in the past, they generally say that if you can pay that within a certain number of months, that they won't charge interest, but after a period of months, they'll begin charging interest. And finally, You can be liable for a violation of the False Claims Act if you are a managing employee in an entity, or if you are a managing employee in an entity that engaged in fraud or abusive conduct. You could be liable individually for False Claims Act violations. Well, what are the penalties under the Idaho False Claims Act? Well, you could be excluded from state health care programs, including Medicaid. In addition, you can be hit up for civil penalties of up to $1,000 per violation, and the regulations that accompany the False Claims Act have different criteria that the government will consider in determining what type of a violation that they will impose. In addition, you can be referred to the Medicaid Fraud Unit, and the Medicaid Fraud Unit could then go after you for additional penalties or violations. Now, one of the troubling aspects of the False Claims Act is that it specifically says that if you breach your Medicaid provider agreement, that you can be subject to those False Claims Act penalties. Now, a lot of you probably haven't reviewed your Medicaid provider agreement lately, but you really should. Under the most recent one that I've seen, it states that the current Medicaid provider agreement requires providers to comply with a broad range of requirements, including you've got to comply with all federal and state statutes, regulations, and rules. Well, what does that mean? That means that if you violate one of those federal statutes, even though Idaho hasn't got a statute on it, you're in violation of your Medicaid provider agreement, and therefore you can also be liable under the Idaho False Claims Act. Now, as a practical matter, I've never seen Medicaid go after anybody for that, but the bottom line is you need to make sure that you're aware of what your provider agreements require and that you comply with those federal rules. Your provider agreement requires that you provide accurate information in any of your applications you submit. You have to be properly licensed, certified, and registered. And to the extent that you're providing services to others that require supervision, you have to make sure that you properly supervise those others. You've got to document services and maintain the records for at least 5 years. This is a really common problem out there. A lot of the cases that I see involve situations where the provider failed to maintain the documentation that is necessary to support the claims. So when Medicaid comes in and does an audit, asks to see your records, you haven't got the records you need to support the claim. And that, whether or not you provided the services, the fact that you didn't maintain those documentation for the required 5 years could result in penalties. You know, there's this presumption against you. And again, that the failure to maintain the records itself could be a violation. When you submit that, claims to Medicaid, you are certifying that the items or services claimed were actually provided, were medically necessary, and were provided per applicable professional standards and DHW rules. The False Claims Act takes the position that according to the provider agreement, you're certifying that these things are accurate. So if you did not comply with that, then you have submitted a false claim to the government, and therefore you could be liable for penalties under the False Claims Act. Just like the False Claims Act statute itself states, the Medicaid provider agreement requires that you repay amounts improperly received and that you can't balance bill for services that are otherwise payable by Medicaid. Again, if you fail to comply with any of these provider agreement terms, you could be liable for civil penalties under the Idaho False Claims Act. That's the False Claims Act statute. That's really kind of the big gun that the government can use, the Idaho government can use to come after you. There are some additional statutes you need to be aware of, including the Idaho Anti-Kickback statute. We spend a lot of time, clients understand the federal anti-kickback statute on the whole, but they don't realize that Idaho has its own anti-kickback statute. And the Idaho anti-kickback statute is actually broader than the federal statute. The Idaho anti-kickback statute says that healthcare providers cannot pay another person, and another person may not accept a payment for a referral for services that are for healthcare services. In addition, the healthcare provider cannot provide services knowing that the claimant was referred in exchange for payment. Well, the net result there is that you can't pay others for referrals, and you can't provide services if you know that somebody was referred to you and received money in exchange for making that referral. In addition, the statute specifically says that you cannot engage in a regular practice of waiving, rebating, giving, or paying a claimant's deductible for health insurance. That probably extends to co-pays or those situations. So just like the federal rules under Idaho, you cannot engage in a regular practice of waiving co-pays because that is an inducement to the patients in order to get care. The healthcare providers don't, or payers don't like it when you do that. Well, what is a violation? What are the consequences for violating the Anti-Kickback statute? Well, it can be a $5,000 fine by the Department of Insurance. In addition, remember, the False Claims Act states that if you violate any state or federal statute, you can get hit up with penalties under the False Claims Act. So you could also be liable for those False Claims Act penalties of $1,000 per violation. Now, a very important aspect of the Idaho Anti-Kickback statute is that unlike the federal statute that is limited to items or services that are payable by federal health care programs, the Idaho statute is broader than that. The Idaho statute applies to all providers. I've actually had discussions with the Attorney General or the Assistant Attorney General dealing with the Department of Insurance, who has confirmed that, yeah, the Idaho Anti-Kickback statute applies to private payers as well as government payers. So if any of you thought that you were tricky by setting up programs where you're paying referrals but not paying people to make referrals, but you're carving out federal programs, well, that may work for the federal anti-kickback statute, but it doesn't work for the Idaho anti-kickback statute. So beware of that additional requirement. What about the federal Stark law? Is there an Idaho equivalent? Well, not per se. As you know, the Idaho or the federal Stark law says that if a physician or a member of the physician's family has a financial relationship with an entity, that physician may not refer designated health services to that entity unless the transaction is structured to fit within a regulatory safe harbor. So it doesn't prohibit the financial relationship. It just says if you've got that financial relationship, you can't make referrals to that entity unless it's structured to fit within a regulatory safe harbor. Now, that's a federal statute. Only applies to Medicare and Medicaid. Idaho does not have the same statute. There is no mini Stark law in Idaho. However, the Idaho regulations, the Medicaid regulations state that health and welfare may deny a payment for any and all claims it determines are for items or services provided as a result of a prohibited physician referral under Stark. What does that mean? Well, that means even though there is no mini Stark law, that if you violate the federal Stark law, that health and welfare can refuse to pay you or recover payments from you that were made per referrals that violated the federal Stark law. In addition, remember that provider agreement? The provider agreement requires that you comply with all federal and state laws, and if you violated the federal Stark law, you're in violation of your provider agreement, which means that you also can be subject to False Claims Act penalties. So the bottom line is, you have to still be worried about Stark in Idaho. Now, as a practical matter, it probably doesn't increase your exposure that much because under the federal law, if you're billing Medicaid, then Stark still applies to Medicaid. So you probably have about the same liability. But just remember that the government, the Idaho department can come after you for violations of the federal Stark law and get recoupments and potentially impose civil penalties. Separate apart from that, Idaho also has fee-splitting statutes. These normally appear in licensing statutes like the Medical Practices Act that applies to physicians. Typically, those will say something to the effect that, specifically in the case of physicians, that a physician and a PA may not divide fees or gifts or agree to split or divide fees or gifts received for professional services with any other person, institution, corporation, in exchange for a referral. So again, you can't offer these kind of kickbacks in order to get those types of referrals. In addition, you can't give or receive rebates for the services, again, designed primarily to avoid those situations where you're paying for referrals. Well, what happens if you violate this? Well, this appears in the Licensor Act. So probably the most immediate consequence is the Board of Medicine could come after you for that if you set up some kind of a fee-splitting arrangement. Now, as a practical matter, the Board of Medicine, I'm not aware of situations where they've really gone after anybody. I have seen letters from the board where they threatened to go after people who set up what they consider to be nefarious or improper referral relationships, and usually after receiving one of those letters, the people correct it and the Board of Medicine is happy. There is a possibility, however, that if you engage in one of those fee-splitting arrangements, that it's possible that the government, Idaho Medicaid, could come after you because, again, remember, as part of the False Claims Act and your provider agreement, it requires you to comply with all federal and state laws. If you are a physician and violating the Medical Practices Act, including the fee splitting statute, then it's possible that you could be held liable for a false claims. We haven't got any cases like that, but just be aware that this fee splitting statute is out there, so you need to make sure that you structure your arrangements out there with potential referral relationships to comply with these fee splitting arrangements. Now, in addition to all of those, Idaho also has its insurance fraud statute, which says that any person who, with the intent to defraud or deceive an insurer, presents or causes to be presented any statement in support of a claim for payment or other benefit, knowing that such statement contains false, incomplete, or misleading information, can be liable for a felony. And that's up to 15 years in prison, a $15,000 fine. Could also result in restitution back to the insurer. Each separate violation, so each separate false claim you submit to an insurance company could be considered a separate offense, and they could come back against you for any of those. So you may think that as long as you are just complying with federal laws applying to claims and you don't have to worry about the state laws. No, you still have to be worried about these insurance fraud statutes, even in the case of private payers. So make sure that you're aware of that. Now, private payers are becoming increasingly active in enforcing claims against or pursuing claims against private entities, providers, for violation of the insurance fraud statutes. They may also use those violations of the insurance fraud statute to assert collateral claims, such as consumer protection claims, maybe civil RICO claims, things like that. So beware of any time that you're dealing with any payer, whether that's a private payer or a federal payer, to make sure that you're on the right side of these insurance fraud statutes. All right, that's a brief overview of Idaho insurance fraud and abuse laws. In the brief materials we provided to you, I've given you a lengthy article that discusses those things in more detail. The bottom line here is just make sure that when you're structuring your arrangements, your transactions, that you not only consider the federal laws, but also consider those Idaho laws. All right, let's talk about the Idaho Patient Act. This is one that took effect on January 1st of 2021, and the whole intent of this was to address surprise medical billing, where patients suddenly get a huge bill that they didn't expect, and then they can also, if they don't pay it in a timely manner, they can also get hit up with what at least the sponsors of the bill thought were exorbitant costs and fees. So generally, the way that it works, that if you fail to provide certain required notices and statements to the patient within a timely manner, you may not take extraordinary collection actions against the patient. This term, extraordinary collection action, is really the guts of this statute. So it's important what this prohibits. It prohibits you from sending a bill to a collection agency before 60 days after you issued or after the patient received a final statement. The final statement has to comply with certain requirements we'll talk about in just a minute. It prohibits you from reporting to a consumer reporting agency adverse information about a patient unless you've taken certain steps. And it prohibits you, perhaps most importantly, from bringing a lawsuit, placing a lien, or garnishing a patient's assets unless you've jumped through these hoops by providing the patient this required notice. Now, note that the statute generally prohibits you from engaging in this extraordinary collection action, these items that we talked about there. Whether or not you comply with those procedural requirements in the Act, you can still send bills to the patient and make your own demands for payments yourself. There's nothing that prohibits that. You could send the bill to a collection agency 60 days after you send the final statement, even though, but the problem with that is you may send it to the collection agency, but the collection agency may not be able to initiate collection activities because that's another extraordinary collection action unless you've jumped through the right hoops. You could fire the patient from your practice because they didn't pay your bill. You could exercise other forms of self-help, but you just can't engage in these extraordinary collection actions. Again, sending the patient to the collection agency before 60 days after the final statement, reporting to a consumer reporting agency, or most importantly, commencing judicial proceedings in order to collect the bill. Now, even then, you could without jumping through those hoops, you could still probably pursue a collection effort. But if you do pursue the collection effort, if you haven't complied with the procedural requirements, you're not going to be able to recover your costs, expenses, and fees. And you could also be subject to penalties, like we'll talk about in just a minute. So if you want to engage in those extraordinary collection actions, and if you want to be able to recover your costs, fees, and including attorney's fees, as part of that, then you've got to do certain things. Within 45 or 90 days, depending on, we'll talk about the difference in just a minute. After the services are provided or the patient is discharged, then you've got to submit those charges to the patient or payers that are identified by the patient. Within 60 days after you provide the services or the patient is discharged, you've got to, or 150 days, if you want a little bit extra time, I'll talk about more of that in a minute, you've got to send this consolidated summary of services to the patient. You've got to submit a final statement to the patient, and then you've got to wait at least 60 days before you send the action to a collection party or you begin to charge interest, and you've got to wait at least 90 days after that you submit that final statement to the patient, and the resolution of any reviews, disputes, or payer appeals basically has been adjudicated before you can initiate those collection actions. Those are basically the guts of what you need to do. Let's talk about each one of those briefly. First, within the 45-day period, you've got to pursue, if you want to go ahead and pursue those extraordinary collection actions, you've got to submit the charges to either the patient or the third party who's identified by the patient as the payer within the 45 days of providing the goods or services to the patient or the patient's discharge from the facility. Now, you can take an additional 45 days, so up to 90 days if you want, but if you take that additional 90-day or the additional 45 days up to the 90-day window, then you can still submit the charges, you could pursue it, but you can't collect additional charges, fees beyond the principals, including your attorney's fees. So it's really going to inhibit your ability to collect the attorney's fees you need to cover your collection costs. So it's important that you comply with this to submit those charges within that 45-day period. In addition, within 60 days after you provided the services or the patient was discharged, you've got to submit a consolidated summary of services. Now, this consolidated summary of services has to contain certain information, including these required statements, those things that appear up there. Now, with that consolidated summary of services, if you don't submit it within that 60-day period, again, you can have up to an additional 90 days after that 60-day period, so up to 150 days after you provided the services or the patient was discharged, you can still submit that consolidated summary of services. But if you take that additional time, again, you can sue the patient, but you're not going to be able to recover the costs and the fees and the additional charges that are going to be associated with that, which again is going to make it less attractive to pursue the claim back against the patient. So again, to the extent that you're required to, it's important that you submit that consolidated summary of services so that you can collect the additional fees that may be associated with those charges. Now, you're not required to send that consolidated summary of services if you are the only person that billed on that particular bill. If the patient will receive a final statement from a single billing entity for all goods and services provided to the patient, then you don't have to submit the consolidated summary of services. The consolidated summary of services was really designed for like hospitals that are billing for a bunch of different providers. If you're just billing for your own individual practice, you probably don't need to worry too much about the consolidated summary of services, but you're still going to want to timely submit the charges. In addition, in order to pursue those collection actions, you've got to submit a final statement. There's not a deadline for submitting that final statement. In fact, the final statement is supposed to include a bunch of information, including a detailed description of any adjustments and payments that were received from the third-party payers. So it may take a while for the third-party payers to fully adjudicate that claim before you can send that final statement. The final statement is really kind of a misnomer. It's, for most of the time, it's not what you would consider a final statement because it's the statement that you're sending, it's probably the first statement that you're sending back to the patient, showing the patient's responsibility. if you submit that final statement, then you've got to wait a certain period of time before you can pursue those, or once you submit that final statement, you've got to wait a period of time before you can pursue those extraordinary collection actions. Now, note that those additional times run from the time that the patient received the final statement, not from the time that you mailed it. So generally, you need to factor in the mailing time. And presumably, if you're going to send the statement by regular first-class mail, then the patient is presumed to have received that 3 days after you mail it. So you're going to want to document when you sent that and make sure that you factor that as 3 days into that time period. Now, if you fail to comply with those requirements about doing the appropriate charge, providing the consolidated summary if the consolidated summary rule applies to you, and sending the final bill, if you fail to comply with that, then you cannot recover the costs, expenses, or fees for the extraordinary collection action. If you decide to sue the patient, you can't recover those additional collection actions. Now, in addition, even if you do comply with those requirements, that you did timely submit the charges to the payers, that you did submit the consolidated summary, and you have provided the final statement, even then, you still are limited in the fees that you can charge. And these limits are pretty dramatic. It really is going to cut into the bottom line of healthcare providers and collection agencies and make it less attractive for collection agencies to take on and pursue bills. Now, there are situations that allow you to, if you have been for whatever reason, maybe because the patient was doing something fraudulent or things like that caused you to incur extraordinary collection costs, then you can petition the court for increased amounts, increased fees associated with that collection effort. But it's probably going to be a little bit difficult to get the court to actually grant those. So you're going to be limited to these fees that you can actually collect from the patient. Now, to make matters worse, if you pursue a lawsuit against the patient and the patient wins on the lawsuit, it says that, no, he didn't owe everything that you're seeking, you're limited in what you can recover from the patient. But the patient can recover all their costs, expenses, and fees. And in addition, they have no liability for those additional fees or costs. So it's really kind of a one-sided deal in addressing these particular situations. Well, what happens if you violate the Idaho Patient Act? Well, if you bring an extraordinary collection action without complying with those rules by sending the timely submitting the charges, sending the consolidated summary if you are obligated to, and by providing the final statement and waiting the period of time before pursuing collection action, if you violate that, then if you bring an extraordinary collection action, even though you violated it, the patient has no liability for the collection costs, expenses, and fees, so you can't collect those additional fines. You're going to be out of pocket for all of those collection costs, including your attorney's fees. In addition, if you violated the statute, even though you can still apparently pursue them for the principal, the provider, you can be liable to the patient for the greater of $1,000 or any damages the patient suffered because of your violation. So yeah, you may be able to recover the principal, but the patient's also going to be able to recover penalties against you of $1,000. That's if you did it kind of ignorantly. If you violated the statute willfully or knowingly, then the patient can recover penalties against you of $3,000 or up to 3 times the damages that are suffered by the patient due to the violation. Plus the patient's entitled to recover their costs plus reasonable attorney's fees. The bottom line is this is a very good example of a bad law. It's an example of a law that had good intentions, but the legislators did not really think about all of the consequences that could follow. I know that there are ongoing efforts right now by a lot of the provider organizations to modify or fix some of the problems that exist in this particular statute. I think that will be brought up during this legislative session. Hopefully they will get some of these issues addressed because it really does diminish your ability to collect medical debts. And if you can't collect the medical debts, then that's going to drive up cost to all of those who pay their debts, right? So that's not in the interest of all of us. So hopefully we can convince the legislators to see the errors of their ways and maybe rein some of this stuff back in. But we'll have to see. In the meantime, those laws on the books, so you got to comply with it. That means, most importantly, you need to send out, timely submit the charges, document the notices that you have to send out to the patient, keep track of the deadlines and the dates that you send all of that out, make sure that you document compliance with those dates, because if you do have to pursue a collection action, you're going to have an affirmative obligation to prove that you complied with all of these requirements. So that is a brief overview and a recap of kind of where we are with that Idaho Patient Act, a real hassle. All right, let's talk about consent issues, because these come up all the time in practices. Bottom line is, hey, patient has a right to consent, right? If you fail to get consent from the patient, then you can be liable for all sorts of penalties. Now, most of you are not going to, throw the patient down on the gurney and perform surgery while they're kicking and screaming. That doesn't happen very often. But lack of informed consent can arise in different types of situations. Maybe it's a situation where the patient lacks capacity to give effective informed consent. Maybe they're physically affected, maybe they're drunk, maybe they're on medications to where they're not competent to give effective consent. Maybe they're mentally deficient, maybe either because of a particular circumstance at any time, or maybe they've got a disability that limits their ability to give effective consent, or they may be deemed incapacitated by statute. For example, as we'll talk about in just a minute, minors, persons who are under age 18, are generally deemed to be incompetent to give their own consent, with subject to certain exceptions. It may be a situation where you ignore a patient's wishes. The patient told you, gave you an advance directive that he didn't want this to happen, and you ignore that, even though you've gotten that prior directive from the patient. It could be a situation where you provide treatment that exceeds the consent. Yeah, you got consent, but the consent wasn't sufficient to cover everything that you're going to do. And so you do this additional stuff, and then only to find out that the patient didn't agree with that or doesn't consent to it. It could be a situation, and this is probably the most common, where you fail to provide relevant information in order to allow the patient to make an informed decision. It's not enough for you to get consent. You have to get informed consent, because if you haven't provided sufficient information to the patient to allow them to make an informed decision, then the consent really isn't effective. Or it could be a situation where the patient simply does not understand. Maybe you're speaking at as a medical professional who's had lots of years of experience, but you're talking to somebody who has a second grade education or a high school grade education, and they have no idea what you're saying. Or maybe they don't speak English as their primary language. Here you're talking to them, and they have no idea what you're saying. Well, that's not effective informed consent. But what happens if you fail to get informed consent? In Idaho, we actually have a cause of action, a tort cause of action like malpractice, that they could sue you for lack of informed consent. They could also sue you for malpractice, for battery, for false imprisonment, for any of these kinds of torts that the patient could sue you for personal injury damages. Informed consent is a defense, but it has to be informed consent. So you want to document that you got informed consent. In addition to those private causes of action that a patient could sue you for, you could be subject to action by your governing licensing board, because, for example, the Medical Practices Act requires that you give effective consent, and if you fail to give effective consent, then you could be, the Board of Medicine could come after you to take away your license. In addition, consent is generally required in order to submit the claims to the payer. So if you have no effective consent, then you may not be able to get reimbursed, or if you do submit claims for reimbursement, maybe you've submitted a false claim and therefore have to repay the government, or the government can come after you for False Claims Act penalties. So informed consent is critical to any of the care that you want to provide. Well, let's talk about what's necessary for informed consent. Well, the first is the patient has to have sufficient capacity. Idaho actually has a statute. Idaho Code 39-4503 says that any person who comprehends the need for, the nature of, and the significant risks ordinarily inherent in any contemplated health care, treatment, or procedure is competent to consent thereto on his or her own behalf. So do you want to know whether the person has sufficient capacity? There's the test. Do they have sufficient understanding to comprehend the need for and the nature of and the significant risks ordinarily inherent in their care? Well, who makes that determination? Well, the statute goes on to say that you do as the healthcare provider. As any healthcare provider may provide such healthcare and services in reliance upon such a consent if the consenting person appears that the healthcare provider is securing the consent to possess such requisite comprehension at the time of giving consent. If there's any question at all about the person's capacity, you're going to want to make sure that you document in the record that this person did in fact have sufficient capacity, or if they didn't, that they didn't have that sufficient capacity. That documentation is very important. Well, what happens if the patient lacks that sufficient capacity to make their own decisions? Well, the next section, Idaho Code 39-4504, says that if the patient lacks that capacity, and by the way, I should mention that the authority to consent to care, the capacity to consent to your own care, also includes the capacity to refuse care. Refusing care is just the other side of consenting to the care, right? So if they have sufficient capacity to consent to their care, they also have sufficient capacity to refuse care should they choose to do so. Well, if the person lacks sufficient capacity, then the statute says consent for the furnishing of health care to any person who has not been capable of giving such consent, i.e., these persons who lack that capacity because of their situation or current circumstances, or any person who is a minor may be given or refused by the following, okay? And then there's this hierarchy. So here, based on this statute, minors are presumed to lack capacity in Idaho. Now, you're thinking, well, wait a minute, 39-4503, that says that any person who comprehends the need can consent to care, right? It doesn't say any adult person, it says any person. Well, that may be right, but the problem is the next section says that the consent for the furnishing of health care to any person who is a minor may be given or refused by the following. So the assumption is that minors can't consent to their own health care unless you fit within an exception we'll talk about in just a minute. Now, the way this statute works is there's a hierarchy, right? You start at the top and you go down to the bottom. So if the person lacks capacity, you look to these people. The first would be a court-appointed guardian. Not necessarily just a person who says they're the guardian. They have to be a court-appointed guardian. Next, a person named in the living will and durable power of attorney. But of course, the living will and durable power of attorney only become effective if the patient's incompetent. If the patient's competent, then the living will and durable power of attorney don't become effective yet, so you couldn't rely on the surrogate's consent in that situation if the patient's still competent. Next would be a spouse. If there's no spouse, you'd look to an adult child. If there's no adult child, you would look to the patient's parent. If there is no parent, then you would look to see whether there's a delegation of parental authority. That simply is a document that where if you're going out of town, you want your kids to be taken care of, you can delegate, you could assign somebody and write out a document that says, hey, the babysitter can consent to their care just like I could. So that would be somebody with a delegation of parental authority. If there's no such person available, then you could rely on a relative. Well, who are appropriate relatives? Well, they don't really say. There's no limit on exactly who the appropriate relative is. You'd have to just use kind of common sense. Could be a grandparent, could be an aunt, an uncle, maybe an adult sibling. They could be appropriate relatives. And if you haven't got that person, then the statute says you can rely on any other competent person representing himself or herself to be responsible for the health care of the individual. So as a health care provider, this is who you look to provide effective consent. Again, you start at the top and you go to the bottom. You would only get to any other person if one of those other persons higher in the hierarchy were not available. Now, who might that be? That could be maybe the babysitter. That could be the coach. That could be somebody else. If the parents aren't available and you need to go ahead and provide care and you need to get consent from somebody. Now, another comment. Note that in this statute it says that these surrogates have the authority provided that the surrogate decision maker shall have sufficient comprehension as required to consent to his or her own health care. So that surrogate also has to have sufficient capacity, right? Doesn't do any good to have an incompetent patient and go to an incompetent surrogate to get the consent. That surrogate also has to have sufficient capacity. Well, let's talk about minors because that's the one that comes up most often. The general rule is, in Idaho appears to be, that minors lack consent unless either the minor is emancipated or there's another statute that allows them to consent, or maybe the mature minor doctrine. We'll talk about each one of those. In Idaho, a minor is probably emancipated and able to consent to their own health care if they are either married or have ever been married, they are in the armed forces, and that's the active armed forces, not necessarily ROTC, if they are living on their own and self-sufficient so that they are not relying on their parents, they've got their own job, their own insurance, that type of stuff, and they've rejected the parent-child relationship, or if they've gone to court and the court declares them to be emancipated. But note that even in this situation where you've got an emancipated minor who comes in, that minor still has to satisfy the basic test, right? They still have to have sufficient capacity to understand and appreciate the consequences of what they're doing. So you may have a 16-year-old, for example, who is married or has been married. They come in, but you conclude that, hey, yeah, you're emancipated, but you still lack sufficient capacity, sufficient understanding, sufficient maturity to understand and appreciate the consequences of what you're doing, and therefore you can't give effective consent. Well, what about pregnancy? Is pregnancy an emancipating event? A lot of people assume that, hey, yeah, if you are pregnant, then you can make your own health care decisions. Well, that's probably not the rule in Idaho, at least according to the statute, because the Idaho abortion statute specifically says the capacity to become pregnant and the capacity for mature judgment concerning the wisdom of bearing a child or having an abortion are not necessarily related. Therefore, to protect minors from their own immaturity, abortions for pregnant unemancipated minors generally require the following: parental consent or judicial findings of maturity, and they're able to consent. The reference to pregnant unemancipated minors suggests that pregnancy itself is not an emancipating event in Idaho. If it were, there would never be any pregnant unemancipated minors. There would only be pregnant minors. So in Idaho, the assumption is that pregnancy alone is not an emancipating event. Now, put an asterisk by that. I'm going to come back and talk to that in just a little bit. Now, in Idaho, there are several statutes that allow minors to consent to their own health care. For example, EMTALA would allow a hospital to go ahead and initiate screening, exam, and treatment based on the minor's consent. In addition, the Idaho statute says that a healthcare provider can render examinations, prescriptions, devices, and information regarding contraceptives if the practitioner determines that the minor has sufficient intelligence and maturity to understand the nature and significance of the treatment. There isn't a set age limit for this one. It's just simply you as a provider have to assume and presumably document that the minor has sufficient maturity to understand the consequences of their decisions. In addition, an important one is that under federal law, if a minor shows up to receive family planning services that are funded by Title 10 of the Public Health Services Act, which would include minors seeking family planning services that are payable by Medicaid, then the minor is deemed to have sufficient capacity to consent to their own health care. Minors can consent who are over age 16 or older, can consent to their own drug treatment or rehab treatment. And in addition, you can't notify the parents in that situation without the minor's consent. Minors who are age 14 and above can consent to their own testing or treatment for reportable infectious or communicable diseases. Minors who are age 14 and above can consent to their own hospitalization for observation, evaluation, and treatment for mental health conditions. Now, note that this one's a little bit problematic because when you read the statute, it's talking about the minor's ability to consent to inpatient care at a facility. It's talking about hospitalization, those types of situations. There's nothing in that statute that expressly allows any mental health care provider to provide care to minors outside of that kind of inpatient treatment facility type situation. So be careful out there if you're a healthcare provider and you think that a minor age 14 can just consent on their own. You may be right, but that's not necessarily what the statute says. So there is some risk there. The safer thing to do would be to seek parental consent for those situations. If a minor is age 17, they can consent to their unpaid blood donations. Those are the main ones that I'm aware of. There may be others that are out there, but those are the top ones. Now, under in most states, they have what's called the mature minor doctrine. The mature minor doctrine basically says, look, if there's no magic about that 18th birthday, right? It's not like the kid is age 17 and they go to bed and they wake up the next day at age 18 and they're smart. So under the mature minor doctrine, most states will say, or a lot of states will say, hey, if the kid has sufficient capacity to understand and appreciate the consequence of what they're doing, the kid ought to be able to make their own health care decisions. Now, the problem is we don't know exactly how that would fly in Idaho because on the one hand, Idaho Code 39-4503 says that any person can consent as long as they have sufficient capacity. But on the other, the very next statute says, and in the case of minors, these are who can consent for minors. So we think that probably a court would assume that the minor cannot consent to their own health care unless you've got a statute that allows them to provide the care or there's an emancipating event. Now, at some point, it may become a constitutional issue. We know that on the federal constitution allows certain persons a right of privacy, and that has been extended to the case of minors in the case of reproductive rights. So it may be that, especially in dealing with reproductive rights, that the minor may have a constitutional right of privacy that would allow them to consent to their own health care, but we don't know. So just be careful before you rely on this mature minor doctrine. Realize that you are doing it at your risk. If you are going to rely on the mature minor doctrine, you're going to want to document key factors, including the age of the child, the maturity of the child, the significance of the services you're going to render. It's one thing to just do something that really doesn't have any long-term consequences. It would be another to do a hysterectomy or something like that that would have significant long-term consequences. I would be more nervous about relying on the mature minor doctrine in those situations. Now, the Idaho statute also says that if you can't find any of those surrogates and the patient's incompetent, then if it's an emergency situation, then the treating healthcare provider can go ahead and act as if they had authorization or consent to provide that care. Just make sure you realize that this only applies when you can't there's not time and it's an emergency situation where you can't get cares from the other. You can't rely on this to provide care that over the minor's objection or without the surrogate's permission if there's time to seek and obtain that consent. Now, there are certain statutes that allow treatment without consent. You simply don't need the minor's or anybody else's consent. For example, mental holds. The Idaho statute allows law enforcement to initiate mental holds at hospitals. It also allows physicians and advanced practice professionals at hospitals to initiate a mental hold if the patient is gravely disabled due to mental illness or the person's continued liberty poses an imminent danger to the person or others as evidenced by a threat of substantial physical harm. In those situations, they can initiate the mental hold, which gives the time for the local prosecutor to go to court to determine whether or not they're going to get a court order that allows for additional treatment. Then in the materials I provided to you, I've given you a lot more information concerning the mental hold statute. Now, I can tell you that when we drafted that, and I was involved in the most recent amendments to that statute, we contemplated that this would apply to all patients, minors or adults. But I can also tell you that a lot of the prosecutors said that in the case of minors, you don't rely on this mental hold statute. Instead, you rely on the shelter care at a hospital for minors, a separate statute under the Child Protective Act. In that statute, it allows police to take a child to shelter care at a particular facility or healthcare providers at a hospital to, if the patient has an emergency condition, and the child is suffering from a serious emotional disturbance, then that hospital can go ahead and hold the patient while they contact the parents. If the parents show up and they refuse to provide additional care that the hospital thinks is necessary, then the hospital can hold the patient for a little bit more time while they contact the police so the police can show up and initiate a shelter care. That they can only do that if that immediate attention and treatment is necessary to prevent the harm of the child or others. So just remember that if you're at the healthcare facility, that in the case of minors, you've got to also be aware of this shelter care proceeding. There are other statutes that allow treatment without consent, such as treatment of an infant by a safe haven. So if the mother or father drops off they can drop off a child at a hospital and the hospital can go ahead and provide necessary care. The statutes allow facilities to perform certain tests and treatments such as PKU or germicide. There is a process that parents may be able to refuse based on religion, but that's usually the parents have to initiate that. There is some statutes that will allow for limited testing or treatment ordered by law enforcement, so they could show up and order, for example, a hospital to provide certain blood tests. But those are very limited circumstances, and even in those circumstances, the healthcare provider can refuse to perform those tests if they think it's a danger to the patient or a danger to facility personnel. And so if that's the case, my general advice to the client is, look, never provide care to never provide care to a competent patient who is combative or refusing to consent to that care because of the potential consequences. Let's talk about the form of consent. Does the consent have to be in writing? Well, in Idaho, no. The Idaho statute says that it's not essential to the validity of any consent that the consent be in writing or any other specific form of expression. You can have implied consent. Patient shows up and holds out their arm. You could take that as implied consent to draw blood or do a blood pressure check. It could be oral. Oral's fine. That's valid in Idaho. It could be written. Now, the benefit of having a written consent, of course, is for proof. In addition, in Idaho, if you have a written consent, it carries a presumption that that consent is valid and sufficiently informed. So having a written informed consent is going to provide you some protection. It's not required in Idaho, but it is helpful and will help protect you if there's ever a dispute. Now, it could be that other states other laws or payer requirements may require written documentation. For example, the hospital conditions of participation generally require written informed consent for surgical services and certain other types of services. So payers may require written consent, but generally, as a general rule in Idaho, consent doesn't have to be written, although as your lawyer, we like written informed consent because it protects you. Well, what do you have to have in order for the consent to be sufficiently informed? Again, Idaho statute generally says that the consent is valid in all respects if the person giving or refusing the consent is sufficiently aware of the pertinent facts respecting the need for, the nature of, and the significant risk. That's generally the test for the sufficiency of informed consent. Hey, have you told that person sufficient information so that they understand the need for, the nature of, and significant risks that are ordinarily inherent in that procedure? Now, whether or not you provided sufficient information isn't based on what the patient thinks you should have told them. It's based on what other similarly situated healthcare providers in the community would have given. So you should be judged by what your peers would have provided in that particular situation. It's an objective test, not necessarily a subjective test by what the patient thinks they should have. Generally, your consent would want to cover certain items. A good reference point is the CMS's conditions of participation for hospitals. It basically says that a valid consent form or a sufficient consent form or a good example of a consent form would have the name and signature of the patient or their legal representative, the name of the provider, the name of the treatment or procedure, so it describes what you're going to do, the name of all practitioners performing the procedure and individual significant tasks if more than one practitioner, so that the patient knows who's actually going to be holding the knife. The risks and benefits associated with the procedure, alternative procedures and treatments that are available and their associated risks, the date and time the consent is obtained, a statement confirming the procedure was explained to the patient, particularly that's important in the medical records if you haven't got a consent form, a signature of the person witnessing the consent. Now, that's not required by Idaho law. It is for the conditions of participation. It's not a bad idea to have them witness it, just in case there's any dispute about what the consent, whether the patient gave consent, or perhaps more importantly, whether the patient had sufficient capacity. The name and signature of the person who explained the procedure to the parent or guardian. Want to emphasize that informed consent is different than a consent form. Informed consent is communication. You talk to the patient understood the relevant risks and benefits. A consent form is just documentation to show that effective communication existed. A consent form should not substitute for informed consent, and a consent form does not necessarily prove that informed consent occurred. You might have lots of situations where you stuck a paper in front of the patient. Patient may have signed it, but probably didn't read it and probably didn't understand it, or you probably may not have given all the information necessary, including that particular patient-specific situations, or responded to specific questions that patient has. So don't get fooled into thinking that just because you got the patient to sign a consent form that you got informed consent. Make sure that the patient understands the key factors going into that decision. To that end, you should evaluate whether the patient is in a condition to be able to process the relevant information when you're getting the consent. You should speak at the patient's level of understanding. Beware language barriers. I know that a lot of you complain about having to get the language line on paying for an interpreter or translator, but how can you get effective consent otherwise? You need to make sure that you're able to communicate effectively with the patient. You should supplement oral communications with written or visual material and documentation, but it should supplement, not replace, that oral communication. And give the patient an opportunity to ask questions and receive answers, and then document the same. Who's responsible for giving informed consent? Well, unlike you may think that it's just the nurses. No, it's the healthcare provider who is actually rendering the treatment, right? Who is ordering the treatment. They're the ones who, by statute, are responsible for making sure that effective informed consent is obtained. Remember that refusal of treatment is just the other side of consent. So if the patient has sufficient authority to consent to their own health care, they also have the authority to refuse health care. And you can't trump them just because you think that they're making a bad decision. What about surrogates? Can surrogates refuse treatment? Well, the statute says that consent may be given or refused by a surrogate, by an authorized surrogate. Now, at some point, if that surrogate is refusing care that is necessary, they may have the right to refuse it, but that may cross the line and become healthcare neglect or vulnerable adult abuse, in which case you would, of course, have an obligation to report that to the government. You can't necessarily just ignore what they say or treat over their objections. Instead, your obligation would be reported to the government and let the government come in and assume authority and then authorize the treatment. Let's talk briefly about advance directives. Advance directives just simply say that, look, if the patient has the right to tell you how they want their treatment to occur if the patient later becomes incompetent. They can do that in many different ways. Idaho recognizes like living wills, durable power of attorneys, the physician's order for scope of treatment or the post form. DNRs are advanced directives. Mental health care directives are kind of like the post form for mental health care situations. But these are not the only forms that are available. The Idaho statute specifically says that, look, any authentic expression of the patient's wishes ought to be honored. So as long as you can document that this was the authentic expression of the patient's wishes, don't get caught up in the forms. You shouldn't care too much about whether or not they dotted all their I's or crossed all their T's when coming up with this durable power of attorney or the like, because the ultimate question is this an authentic expression of the patient's will? If it is, then you can rely on that, even if it's scribbled on the back of a napkin and signed by the patient or whatever. As long as it's an authentic expression of the patient's will, then that's what you ought to be doing, as long as the patient's competent. But you're going to want to make sure that you document that. The patient has a right to revoke their advance directive at any time, pretty much by any means. So if they give you any indication that they want to revoke that advance directive, that's going to be effective. You just want to make sure that you document. Along those lines, there's a common misunderstanding. They think that advance directives are automatically revoked in the case of, for example, surgery. That is not the case. We amended the statute a few years ago to clarify that. Just because you don't want them to have an advance directive in the case of surgery doesn't mean that you can unilaterally revoke that advance directive. The key there is to have that conversation with the patient in advance and either get their authorization, document their consent to suspend that advance directive during surgery, or refuse to provide the surgery. Tell them that that's your policy, but in whatever you do, make sure that the patient understands that limitation, and it's the patient's decision. Idaho has a new statute called Simon's Law. This is a situation where the gist of it is that if a hospital or a health care facility that they may not institute a DNR or withhold artificial life-sustaining treatment for an unemancipated minor unless they've made reasonable efforts to contact both parents. And there's a process that you go through. Once they've contacted the parents have to have at least 48 hours to request the transfer from the facility before instituting that DNR to give them time to effect that transfer. If that transfer is requested, you must continue to provide care for at least 15 days while that transfer is accomplished. It doesn't come up very often because almost always you're going to want to contact the parents. You're not going to unilaterally invoke that anyway, but nevertheless, there's a new law out there. Make sure you're aware of it. Let's talk about telehealth, and I apologize. We're probably going to go over a few minutes. For those of you who need to jump off, feel free. Otherwise, we'll just continue on. Idaho has its own telehealth laws. Telehealth is not a federal statute. It's not regulated on the federal level. It's regulated on the local state level, at least currently. Idaho's Telehealth Access Act addresses certain items, including the scope of practice, what's necessary in order to establish a provider-patient relationship, evaluation and management, prescriptions, informed consent, and so on. Now, the Telehealth Access Act applies across all persons who are licensed by Idaho Code 54, which are pretty much all your licensed healthcare providers. In addition to the statute, the individual boards then can promulgate additional regulations that implement the Idaho Telehealth Act. For example, the Idaho Board of Medicine has its own telehealth standards that have to be satisfied in addition to the Idaho Telehealth Act. Dentistry also has some, psychologists also have some. Last time I checked, other licensing boards did not have additional regulations governing telehealth, but they would still have to, at the minimum, comply with the Idaho Telehealth Act. So let's talk about what some of those requirements are. Well, first is licensure. Does a person providing telehealth services in Idaho have to be licensed in Idaho? Well, the Idaho Telehealth Access Act says that a provider offering telehealth services must at all times act within the scope of the provider's license and according to all applicable laws and rules, including but not limited to this chapter and the community standard of care. We think, and I can tell you the Board of Medicine thinks, that means that a telehealth provider reaching out and providing services in Idaho generally has to be licensed in Idaho to provide those services. Now, I don't think it's quite as clear as that, but nevertheless, that's the way the Board of Medicine views that. And the Board of Medicine regulations are more specific. It specifically says any physician, physician assistant, respiratory therapist, et cetera, who provides any telehealth services to patients located in Idaho must hold an active Idaho license issued by the Idaho State Board of Medicine. Now, in the era of COVID, the Idaho Board of Medicine suspended that rule for Idaho licensure. So while COVID's pending, the Board of Medicine has said that physicians and PAs with a license in good standing in another state will not need an Idaho license to provide telehealth to patients located in Idaho during the response to COVID. So they don't have to have an Idaho license under the Board of Medicine regulations, but they still have to comply with federal law concerning prescribing COVID, and they still have to comply with other provisions in the Idaho Telehealth Access Act. Well, that's the current status of it. What about post-COVID? As some of you may have heard, Government Little was trying to ratchet back some of the regulations, and there's a question about, well, how is this going to affect the licensure requirements once COVID's over? The long and the short of it is I can tell you the Board of Medicine thinks that it is still going to require the board, that physicians and PAs and others who are licensed subject to the authority of the Board of Medicine, that they still have to be licensed in Idaho once COVID goes away. There are plans right now. Some groups are pushing in order to remove that requirement. So anybody who's licensed in another state can still practice in Idaho. But we will have to see how that plays out over the next little bit, particularly this legislative session. If you have an interest in that, you may want to contact the relevant lobbyists so that they can put your 2 cents in. All right. So the first requirement is you have to be licensed unless it's waived during the COVID situation. Second, even in those situations, you've got to comply with the standard of care. So even if you're licensed, you can provide the telehealth, you still have to ask, okay, is providing telehealth, though, the standard of care? Are you going to be able to provide satisfy the standard of care by by providing telehealth, or would you need to provide in-person services? Both the Idaho statute and the Idaho Board of Medicine regulations specifically say that you're going to be judged by the in-person standard. The telehealth regulations for the Board of Medicine states that the provider is personally responsible to familiarize him or herself with the applicable Idaho community standard of care. And if the patient's presenting symptoms and conditions require a physical exam, lab work, or an imaging studies, then you've got to do that before you can provide services through telehealth. In addition, you've got to establish a provider-patient relationship. Now, it used to be, the rule was that you couldn't do that through telehealth. They amended that. The Telehealth Access Act allows you to establish that provider-patient relationship via telehealth. It used to be that you had to provide that through a two-way audio-visual communication. This year, they amended that so that you can establish that through two-way audio or audio-visual. So you could establish that patient relationship via a telephone call as well as a video conference. There are certain exceptions that you can provide telehealth without having that or first establishing that provider-patient relationship, where, for example, you're taking call for another person who's a member of your group, or it's an emergency situation. But the general rule is you have to establish a provider-patient relationship before you can render that telehealth service. As part of that provider-patient relationship under the Idaho Board of Medicine regulations, there's certain things that you have to do. During that first contact with the patient, you've got to verify the location and identity of the patient. You've got to disclose the provider's identity, their current location, and the telephone number and Idaho license number of the telehealth provider. That's probably not being done, but there it's in the regulations you're required to give that information. You've got to obtain appropriate consents from the patients after disclosures regarding the delivery models and the treatment methods or limitations associated with it as part of that informed consent stuff we'll talk about in just a minute, including special informed consent regarding the use of telehealth technologies. And you've got to allow the patient an opportunity to select their provider rather than being assigned a provider at random to the extent that it's possible. As part of your evaluation and treatment, prior to providing the treatment, you've got to, including the prescription of a drug order, the provider's got to obtain document a patient's relevant clinical history and current symptoms to establish the diagnosis and identify underlying conditions and contraindications to the treatment recommended. So you can't just simply give them the pill or prescribe the pill without doing an appropriate workup for that, getting the history and the like. Treatment based solely on an online questionnaire, they specifically said that both here and in the Idaho prescribing statute, that's not enough. Online pharmacies, that doesn't work. You've got to make sure that you establish that relationship and that you get the documented history, and just simply having them complete an online questionnaire is not good enough. When it comes to prescriptions, generally, the Idaho statute says that if you've got an established provider-patient relationship, you can issue prescriptions through telehealth. But, of course, you've still got to comply with the federal rules governing controlled substances, and those have certain requirements. However, during COVID, the DEA has relaxed some of those requirements to allow prescribing via telehealth, as long as it's for a legitimate medical purpose by a practitioner acting in the usual course and scope of their practice. Telehealth communication is conducted using audio-visual, real-time, two-way interactive communication system, and the practitioner is acting in accordance with the applicable federal and state laws. You can go onto the DEA website, and it's got information about that. In addition, as part of the telehealth process, you've got to have a specific telehealth informed consent. In the statute, it says that it must be obtained and maintained at regular intervals consistent with the community standard of care. In the Board of Medicine regulations, it has specific requirements of what your informed consent for telehealth has to include. So you're going to want to make sure that you modify your consent forms in the case of telehealth to include these issues. You've got to identify the patient, provider, and the provider's credentials. You've got to have the patient's agreement that the provider will determine whether or not the condition being diagnosed and or treated is appropriate for telehealth services. So you as the provider have to make that call. And that the information you've got to provide them with information on security measures regarding the telehealth technology, such as encryption, password protection, and the like, and the risks associated with using telehealth, and that it may mean that their information is not secure and may be more subject to a loss. And you've got to warn the individual that the information may be lost due to technical failures. You've got to be in a position to provide appropriate follow-up care, and you've got to be familiar with the local available medical resources so that you can refer the patient if the patient needs other services. You've got to maintain appropriate records concerning the telehealth, and those records have to be available to the provider consistent with HIPAA requirements. In addition, under the Idaho board regulations, your medical records should include the following: patient-related electronic communications with the patient, prescriptions, lab tests, evaluations and consults, relevant history, instructions obtained or produced in connection with the utilization of telehealth technologies like the informed consent and the like, and the informed consent. Well, what happens if you violate the Telehealth Access Act? Well, at a minimum, you can be liable for adverse licensure actions. The board could come after you. In addition, there isn't any per se violation under the statute per se. They defer to the licensing board, but it's possible that these standards that are now set forth in the Telehealth Access Act may be used as the applicable standard of care. And if you fail to comply with those standards, then you may have engaged in what's called negligence per se. So it may form the basis of a malpractice action against you. So make sure that you review your telehealth practices and that they're consistent with these Idaho statutes. Now, remember, that only applies to providers who are providing services into Idaho. To the extent you're in Idaho providing services in another state, you're going to have to look at the other states' laws. Real quickly, just in wrapping up, a couple of other new laws that came out. The first is you've now got an obligation to check the drug history before prescribing certain controlled substances if the person is subject to a prescription drug monitoring program. You've got to go back and you've got to look at their prescription history for the past 12 months. Reviews not required for patients receiving treatment in an inpatient setting at the scene of an emergency or in an ambulance, in hospice care or in a skilled nursing facility, or for a prescription in a quantity that won't last more than 3 days. So make sure you're aware of those new that new requirement that you check the drug history. And finally, let's talk about Covet Immunity. Under the federal statute, there are different statutes that provide immunity for providing certain types of COVID care, but it leaves a lot of gaps. And this summer, Idaho passed its own statute. Under Idaho statute, it's pretty broad. It says an entity is immune from liability for damage or an injury resulting from exposure of an individual to coronavirus. Now, this isn't necessarily geared towards medical malpractice. It's not malpractice in treating a coronavirus patient, probably, but if you fail to take steps and because of that others are infected, then you may be safe there. The limitations to this particular statute, it does not apply to public health districts, federal or state of Idaho agencies, except colleges. It does not apply to acts or omissions that constitute an intentional tort or willful or reckless neglect or misconduct. So if you're acting willfully or recklessly, you can't necessarily rely on this immunity. It does not modify workers' comp laws, so your own employees can still file their workers' comp claims. And most importantly, it expires July 1st, 2021. Well, what does that mean? I'm not sure exactly. We don't really know. Does that mean that it only applies if suit is brought before July 21st, 2021? Does it mean that as long as the act that gave rise to the suit occurred before July 21st, 2021, that you can still rely on this later? We really don't know. We're going to have to watch this and see what happens, particularly this legislative session. All right, that's a quick overview of some of the new issues on compliance in Idaho, as well as some of the common issues we address in Idaho. Wanted to make sure that you're aware of it. If you want more information about these or other compliance issues, you can go to our website. It's all free there. We've got webinar recordings on a lot of compliance issues, a lot of publications that are available for you. In addition, we've got our ongoing compliance webinar series for the next month or two. Keep track on that, and if there's any of those additional programs that you have suggestions you would like to have us covered, by all means, shoot me an email or a text. If you have any questions about anything that we talked about today, you can submit those using the chat feature, or you can shoot me an email, and I'll try to respond to those as quick as I can offline. Otherwise, thank you very much for participating. I apologize that I went a little bit over, but we had a lot to cover. Thanks much.